everybody! Welcome to New Show Plus, a show run by MinnMax, where every week you, the beautiful supporters on Patreon of patreon.com/MinnMax with 2 N's, get to choose on a new show for us to do. And y'all are a bunch of nerds because you chose me again. Yay! Thank you so much, Hitmonchan. I voted for this. Thank you, Hitmonchan. So last week, I did a show called Haley's Laws, Claws, and Claws. And we talked a bit about terms and conditions and privacy policies for video games and kind of what that encompasses. But this time around, it's still Haley's Laws, Claws, and Claws, I suppose. And I have trusty white claw right here because that's the third clause, is the clause. We're going to be talking about video game mechanic patents. So I feel like it's something that gets talked about, but not a lot of people know a lot about patents, and patents are one of the most complicated areas of IP law, so I'm really excited to talk about it. Context is, I am a video game lawyer. I'm called to the bar for real, no fooling, and I love video game law, and I love intellectual property law, so I'm really excited to talk about this. And actually, what we're going to talk about today, I actually wrote like a 10,000 word paper for once before. So to prepare for this, I just kind of read my own paper and was posthumously like, nice, Haley, good job. So that's kind of nice. I didn't have to do such crazy research. I already researched this back in 2021 during COVID. So time well spent, I suppose. Top of the show, when discussing legal topics, you guys are going to be able to recite this yourself soon if you keep voting for this show. When discussing legal topics, information is provided for informational purposes only, capital letters only, and does not constitute legal advice. Boring. Conversations between myself and anyone in the chat doesn't establish a solicitor-client relationship. No professional relationship is formed by interacting with the channel or me without a retainer agreement or an engagement letter. I don't warrant the quality, accuracy, or completeness of any of the legal information we chat about today, and no person should act or refrain from acting based on what I talk about today. Isn't that fun? And another kind of disclaimer is, although I have a lot of knowledge about patent law, I'm not a patent agent. So a patent agent is someone who specifically like drafts patents for the patent office approval and like has a bit more knowledge exactly how you file and detail patents. We have a patent agent at my firm I work at, Voya Law, and he's the best. And I always want to pick his brain with this kind of stuff. But so I know about patent law, I'm not a patent agent, just a disclaimer up front, but we can still talk about lots to do with patent law. Oh my gosh. So we have so much to cover today. I also want at the end of the show, near the end, to actually look at some video game mechanic patents. And watching the last video, I noticed there were so many good questions and we just couldn't get to them all. So chat's up on the screen. Yippee! Hi, chat. And I'm going to try to answer as many as I can while still being within our little time frame, because it's going to be hard to explain patent law in an hour, but we're going to do it, and you're going to know so much about patents by the end of this. Okay, so patent. What is a patent, Haley? I've heard that. What a loaded statement. What is a patent? So there's really three main types of intellectual property law. Copyright, which, we talked a bit about last week. Trademarks and patents. So those are the big three. There's also trade secrets, little secrets, but those aren't actually like formulated under an act, like a trade secret act. Like they can be legislated a bit, but we don't need to talk about trade secrets. I'm already getting off topic. But so today we're going to be talking about patents, which are legislatively granted things. There's the Patent Act in Canada, and the U.S. also has its own patent act. I think you guys call it the U.S. Code, Title 35. Very beautiful name. Good job, America. I love the name. So let's start first with, I think, kind of what the most important thing to think about. Oh, I should probably crack a claw, shouldn't I? Let's crack a claw. Little sip. Delicious. I just opted for the black cherry this time. Black cherry only today. Sorry, no variety pack. But why protect intellectual property? Because a lot of times, especially with patents, it can kind of feel like, why is this even getting granted? This is stifling creativity. This is just stopping other devs from... I did go through the whole variety pack in a week. Don't judge me, Hitmonchan. It was a long weekend, baby. It was Labor Day weekend. Just gonna drink some claws. So why protect IP? Because a lot of times it can be frustrating when this type of intellectual property regime is applied to a historically very creative and free forming industry like the video game industry. So I kind of like to talk about that really quickly at the top of the show. So there's a few theories on why we protect things this way and why it's even worth it. So there's the utilitarian theory. So this theory is kind of like we need to incentivize people to make stuff, otherwise they won't make stuff. It's kind of a bleak view of humanity, but it's a realistic and capitalistic view of humanity, that someone is not going to put a bunch of time and money into inventing something if there's not a guarantee they can get that money back by getting a monopoly on the product. So, it's kind of sad, but that's like the realistic side of it is people will invent cool stuff unless we give them a little carrot on a stick reward. Here's your patent. You get 20 years is how long patents last. 20 years complete monopoly in the market for your invention. So that's kind of the quid pro quo is you have to disclose your work to the public and have it all detailed in a big long patent application, but you only get that monopoly for 20 years, and then everyone in the whole world can use it and it's in the public domain. So that's the trade-off, right? Oh boy, I am not making stuff for free. Exactly. Gotta get that bread, baby. And without these incentives, they might not actually recoup the money they spent to make those things. This is more so for pharmaceutical or medical stuff, because you can still sell your game even if you're not patenting things in it and commercialize it, but that kind of logic kind of lends itself more towards medical fields or construction or that kind of thing. But there's also the natural rights principle, which I think is super funny. That's just that this is more so for copyright, but just that if you make something, it's a part of you, and you should be able to control and protect manifestations of your personality. This is a very old school way to view the creation of things. I'm thinking more paintings and books and stuff. It's this is me and I should be able to control me. That's the logic, I suppose. An interesting thought. There's also just straight up labor theory. It comes from the fruits of their labor is the logic there. So intellectual labor is labor. Thinking and coming up with things is labor. And if I do that labor, I should be able to make money off of it is kind of the logic there. And then kind of the more newer one that fits itself more nicely to the video game industry, I think, is distributive justice theory. So this is the thought that we need to be more concerned about how resources are distributed in society, and if anything, be more open to sharing IP within a greater group of people. So there's a lot of different companies that, and social movements and things that kind of focus on this, like Creative Commons, if you've ever heard of that. It's actually, I love Creative Commons. They are a website and a company that's trying to essentially have a huge database of free intellectual property you can use via their license. So they're still granting you a license to all this stuff, but there's no money associated with it. What you might still have to do is have the moral rights be attended to. So the moral right of attribution. So maybe just list the person's name under your video or Instagram or whatever when you're using someone else's stuff. But largely, other than that, it's here's a bunch of stuff for you to use. Creative Commons, I like them. So this is the kind of thought behind these sort of ideologies is we need to be more open with sharing IP, and it just allows for more creativity. While still maintaining control, so people want to make things. So having the right of attribution still be applicable, things like that. A little medium. So those are some. There's also a bunch of other ones. We don't have to get into them, but that's kind of. I want you to have that ruminating in the back of your brain. It's why are we even doing this? Why did someone sit down and write the Patent Act, right? Sometimes these things are just in front of our face and we don't think about what's the why even do this? This is kind of a weird system. And it's these kind of things that kind of float around in the background. It's we're trying to do this so that people make things, so that people make money off the stuff they make to make more things, and blah, blah, blah. So these kind of thoughts behind creation, all that kind of thing. So with that ruminating, what are patents? What does that even mean? So a patent is it's a protection for 20 years in the market, so that when you invent a new useful art, process, machine, manufacture, composition of matter. Here, look, I'm literally reading the definition here for invention under the Canadian Copyright Act or Patent Act, or any useful improvement of any of those things. So if I invent that, I get a monopoly on the market to be the only one allowed to sell it unless I grant someone a license to it. And assuming that the patent is approved by the patent office. So each jurisdiction has their own patent office. Canada's and USPTO is the US one. But of course, you can't just patent everything. And what you need to know about patents before we talk about them in terms of when's the last time someone made a new composition of matter? Sounds hard. It's probably chemistry or something. I personally don't look at the composition of matters one. The art ones are fun. And then process is a very common thing. And you'll see the word process a million times in the patents we look at today. But process and machines are kind of the video game ones we're going to be looking at. But mostly process. That gets into... Oh, there's so much to talk about. We have so much time. Claude, Sippy. We don't have a lot of time, I mean. So, I want to highlight 3 things a patent needs in order to be approved. So it's not... I can't just say, here's a toilet seat cover, give me my patent, right? Like, there has to be 3 main things going on with this invention before it gets approved by the patent office and they give you your patent and you have 20 years to be the only one allowed to sell it and commercialize it. So I'll say the first 3 at once and we'll go one by one. So it has to have novelty, so it has to be new. It has to have utility, so it has to be useful and solve a problem. And it has to be non-obvious, so it can't be obvious to someone called the posita, which is like the best acronym ever. And I'll describe who the posita is. You're like, who's that guy? Not obvious to the posita. So starting with novelty, is it new? That's like probably the easiest one to wrap your head around. Now that kind of leads into disclosure. So you probably heard of NDAs, non-disclosure agreements. So that language kind of stems from the idea that with patents, you cannot have disclosed your patent prior to filing. And if you have, you don't get to have a patent. Now there's certain like details that will let you still do it within a year of the disclosure happening in the US and Canada and some other places too, but largely, in a lot of other jurisdictions, if you post about it online, if you write about it in a magazine, if you share it with your aunt, if all this kind of stuff, it's considered disclosure and you can't patent it anymore. Amazing question from Hitmonchan. Do people approving video game patents know anything about video games? Amazing question, kind of the whole premises of this chat. Not really. Some of them do. I've seen some interesting, like, they're called dossiers, when they write back and explain why something wasn't approved. Like the Nemesis system has some really good dossiers where they're like, because it didn't get approved for so long, of them being like, no, like, what about this game? And like pointing out video games. I'm like, nice, they actually know that game. But largely what's frustrating right now about this, the way that this system's getting applied to video games is that it's hard to understand and categorize video games as prior art, which is like the novelty requirement. So before someone patents something, not only do they have to make sure that their thing is new, they also have to make sure they're not infringing someone else's prior art. So my toilet seat cover. If I make a stinky toilet seat cover, I'm like, whippy, I'm gonna get a patent, I'm gonna be rich, rich, rich. And I go, and then some other guy is like, I invented the patent seat cover forever ago. Like, what are you talking about? So then I can't have my patent because it's already invented. It's already exists in the market. So why should I get a monopoly on that if it already exists? And either someone already has made it and they're in their patent protection period, or it's not protected by patents at all. Either it's in the public domain because it's been 20 years since it got invented, or someone else invented it and just disclosed it and didn't want to patent it. Why should I, stinky Haley, coming in forever later thinking she invented toilet seat covers, get to patent that? That's ridiculous. So if it's out in the public and it's used already, you shouldn't be able to get a monopoly on it, is the logic, because then you're just being greedy. You shouldn't get that. So another thing to think about too is that patents with... Oh, sorry, my dog's barking. Patents can also be an improvement on any art, process, machine, or manufacture. So you see it here. My dog's being funny. And was something interesting that my IP teacher taught me when I was in law school is actually apparently 90% of patents that get approved are improvements on previous technology. So it's not a lot of people coming in inventing something totally fresh and new, like a toilet seat cover. It's people improving on previous technology and making it better than before. And that can also be inherently patented itself, so long as you're not wholly relying on the previous technology. You have to have an inventive element to it, and it's now its own thing, even though it's an improvement on previous technology. So you can also get improvements there. So yeah, exactly. A special toilet seat cover. What if my toilet seat cover had a cup holder and heating and something else? I'm sure all this already exists, but you understand what I mean. I can take the toilet seat cover as the prior art, improve it, and now my new useful improvement of my invention is the toilet seat cover with a cup holder. Amazing new invention, and potentially that could get. I know, we're actually having a cup holder and toilet seat maybe a good idea. But I've just disclosed it. I just talked about my amazing invention. So guess what? I can't patent it now because I talked about it too much. Plus, it definitely already exists. So what people will do who want to find patents is the first thing they will do is go on and do patent searches. And some lawyers' whole job is just to do patent searches. Like, it's crazy how much work can go into it, especially if you have a highly, highly detailed and like tricky to describe type of tech. Like, people with engineering degrees go on to do like be people who file and write patents and do patent searches. And patent search, like all the patents everywhere, is just like freely available for you to search online, because that's kind of the logic, right? If I want to know if I'm infringing someone else, there should be a database that tells me every single patent ever approved. So yeah, that exists. Here's the Canada one. Look at that. Do you want to use the bilingual search? Our French kings and queens are loving the bilingual search. We need a little French action. So you can type in here and try to find your, like, any kind of similar art. Obviously, a basic search is not something like a patent search lawyer would be doing. It would be more like doing advanced searches. So here you can see you can really get into detail of what kind of text field you want to look at. Inventor's description, claims, abstract. And there's also software which is wholly designed that lawyers can buy, or like anyone could buy, that help you search for similar tech to yourselves. I had this one, for 1 year I had access to this this patent search software called PatSnap, shout out PatSnap, and it was like the Ferrari of patent searches, and it was so amazing. And I only got it because it was like a school like Lent thing. It was like for a clinic I was working with, and oh my god, I had so much fun with it. And it's like this times a billion in terms of I was making up graphs. I loved it. But anyways, getting too nerdy there, Haley. This is the US one. So patent search basis from the USPTO. Would you do a search by each country? Amazing question. Yes, you would. So patents are jurisdictional. So if I want my stuff protected in Canada, I file in Canada. If I want Canada, US, I file both. If I think Japan might be a good market, I file in Japan too. You essentially have to file in every jurisdiction that you want protection in. And each jurisdiction has their own patent act that you have to know about and apply your patent to specifically. So it can be like tens of thousands of dollars if you want to file something and have like a decent amount of coverage for the specific markets you want to be entering. And you shouldn't really be spending the money on markets you don't want to enter. It might be a waste of money. There might be reasons where you would. I don't really know with that kind of strategy stuff. But largely, you just want to be looking at the markets that you're going to enter into. Hi, Crater! Episode 2. Woo! So there's also like a whole detailed test for anticipation of disclosure. So like whether sharing with your aunt counts or not. There's like a test you can apply that the court's made up. We don't have to go through the whole test because that's a bit too much. But that's how detailed it gets. Like, when I shared it on a Discord server with only one other person in it, is that disclosure? Maybe. We would use the anticipation test to determine that. What if I disclose it to you and then you go out and patent it? I can't patent it because you disclosed it to me. So now neither of us can patent it. There's a Suits episode about that. I forget what one it is. But I was actually like impressed by the Suits knowledge of patent law. There's like some guy with a cell phone patent, and he was selling it to Suits is very popular again. He was selling it to some big conglomerate who were all under NDAs. So again, it's not disclosure if someone's under an NDA. That's why we do them. So if I got you to sign an NDA and then I showed you my invention, it doesn't count as disclosure. But if I showed it to somebody and they didn't sign an NDA, it could potentially count as disclosure if the anticipation test is passed. That's the D in NDA. Yes, disclosure. So that's why a lot of times when you come on to a new job or whatever, you'll have all this like non-disclosure language, and they just want to, just in case you ever invent something that might be patentable by the company, it doesn't count as disclosure because you invented it or was talking about it during work or whatever. Like, so that's the logic there. It's also just to make sure that you don't talk about other company things, but there's also the protection there for that. All right, so that's novelty. It has to be new. What does the MinnMax NDA look like? I can't remember, but I don't think there was one. I write employment agreements every day, and ICA agreements every day, and really it kind of tends itself to the market you're in. Like a video game like Patreon company wouldn't really need non-disclosure language, right? Because everything you do is public facing. But like something like if I worked in tech, if I was making things, if I was a lawyer, those kind of things like have built-in, like you need non-disclosure language because you're making assets that could then be patented or sold or commercialized, that kind of thing. All right, utility. Second step. So we did novelty quicker than I thought we were going to do. I'll do a little sippy. MinnMax should patent something for fun. Ooh, new show plus. What should we patent? Coming up with a MinnMax patent and writing the patenting application. That would be insanely difficult. We could do it though, even though technically doing it on a show would be disclosure. Who cares? But we're learning that that's the thing that stops you from getting it. All right, utility. Is it useful? Does it solve a problem? A patent has to have utility, and it has to be able to. Like someone could read the claim and of the patent application and be able to follow it almost like the instruction steps on a Lego set and be like, I know how to build this now. I can make it, and use that in order to make it. And that should help them solve a problem that previously couldn't be solved without the help of the patent, or, you know, like was more difficult to solve without the help of the patent. So how do you determine usefulness is kind of hard, but there's obviously a million cases that talk about it that we don't need to get into, but essentially you could decide this by commercial success. Like, so if the thing is already out, but you're patenting it, then I know I just said disclosure stops you from filing it, but in this example, someone disclose something, they have 1 year to file. We'll pretend they're in the US because there's a 1 year filing grace period after you disclose. So now the clock's on and you have to file your patent within 1 year of disclosure, which is a lot of money. So sometimes people can't file in time. And then it's doing amazing. So obviously it's selling a ton. People love it. That's kind of an indication that it's useful because of its commercial success. People are obviously using it and finding it useful. If something hasn't been released yet and you're trying to determine if it's useful or not, there's another whole test that the courts came up with called sound prediction. I'm not sure if the US has this too, if it's called something else, but our patent systems are very similar. So I'd imagine you guys have the same thing and it's just called like sound anticipation or something. But it actually comes from the same case in Canada that the test for anticipation also came from. Huge case called Apotex. We had to read it like a million times in my IP, all my IP courses. So there's like a whole format you can go through to try to anticipate if something is going to be directly useful or soundly predictably useful in the future once it comes out. Usefulness is an important element, and usually with software and tech and stuff, even though these are kind of weird patents getting approved, usually usefulness isn't like the thing people are questioning. Usually they're questioning novelty or if it's even eligible to be patented in the first place. Crater, what if you stream it on a non-public stream and put the link for an NDA and claim that link means you agreed to the NDA? Yeah, sure. If you stream on a non-public stream, so just like a video, and put the link for an NDA and claim that, yeah, I mean, then it's privatized and stuff. You might have to look at the terms and conditions of the streaming service you're using and make sure that they're not ever looking at it, because then, technically speaking, if they have access to that software, then they could go and look, and that could count as disclosure. And then you would have to do the whole anticipation test for whether the software company that houses your video and their potentiality to see it could count as disclosure. You see how complicated it gets? That could be a case that's already happened. And that's why patent law is kind of I find it's the most I don't know if it's the most difficult to understand because copyright's also its own crazy beast that changes like year to year, it feels like. But patents are very complicated. And once we get to the patent, like actual filings in a sec, you'll see like the language is wacko. Like you're like, what does that even mean? It sounds like someone is just like slurring their words and writing method and process over and over again. Can a patent be revoked? Like if prior disclosure is found after the fact or something? Yes. So that's what happens all the time is people can challenge patents and say it doesn't meet the novelty requirement because there was prior disclosure or prior art. It doesn't have utility. It's not useful. It's not obvious to the posita, which I skipped over. We'll talk about that in a sec. Or it's not even eligible for patent protection in the first place. So people can come and propose this, and essentially they go to court and they argue this, and then either they revoke the patent or they say no, the patent stands, and usually the person who tried to attack it has to pay a bunch of fees. So it's kind of like a risk, right? Like and what's hard is like the little guy isn't out here trying to stop a bunch of patents. It's the big companies that do it because they have the money to go after that kind of thing. But good question though. Yeah. So the patent examiner in whatever jurisdiction you're filing approves it, and then like logically speaking, the patent examiner should be not approving things that don't meet these criteria that I'm talking about. But it can happen all the time, and it happens with video game mechanics patents, as we can see. So that's what's tough about this is like they might squeeze through. And especially when patent examiners might not have video game knowledge, like know every video game ever to know prior art for video games. That's like the really hard to understand. Like that's the really tough spot about this industry. So they'll like, you know, Warner Brothers will file, it gets approved, and then it's up to like one of us or another company to go on and poke at it and say this should be revoked because there's no novelty and I don't think it's legible subject matter. And then I have to go to court and argue all that, and then either the thing gets revoked. Like usually people only are attesting that and trying to get it revoked if they're getting sued by the original company for infringement. So like say if I made a video game that had a Nemesis system and then Warner Brothers sued me, I'd be more like poised and like want to then question the patent because I'm getting sued anyways. So I might as well go on there and try to be like, okay, well, yeah, he's suing me for infringement. Warner Brother, the Warner Brothers, but I don't think he should have this patent in the first place. So I'm going to say, question, like, should he even have this? And therefore, if he shouldn't have his patent, I didn't infringe it. So that's kind of the logic there too. But someone could also just attest, like, I want to make this tech and this patent's in my way. I'm going to question the legitimacy of this patent application. So that's like the two ways I guess you could do it. But I would say the former, where you're getting sued and then you have to come up and argue that it's not patentable material, might be the thing that happens most. I don't actually know though. That's a good question. Finally, non-obviousness. Okay. And I've also been just looking at the patent search database forever. I'm sorry, that's so boring. Let's do this really quick. So, is the subject matter non-obvious to the posita? Who's the posita? So it's the person of ordinary skill in the art. Like that's literally what the person's called, posita. And the U.S. Patent Office, Canada Patent Office, all that, they call it the posita. It's like a very commonly used term. So who is that? So the posita will be whoever has general knowledge in the field in which you're trying to patent your work. So, for example, if I was patenting a computer chip, a posita wouldn't be like me, who knows nothing about computer chips, and trying to discern if I think that this claim is non-obvious, because I'm like, oh my god, this is so complicated. Of course this is not obvious. Look how hard this is. It's somebody who has general knowledge of making chips or whatever. So like a technical engineer. So a technical engineer would be the one that has to look at a computer chip application, and with all their background knowledge in the field, the person of ordinary skill in the art, they would say, oh yeah, this is like super obvious to me. Like you shouldn't even patent this. Like I do this every Thursday anyways. Like something that's exceedingly obvious to somebody who works in that field shouldn't be patentable, because if it's obvious, then where's the incentive element? Like you have to think and actually like be creative and inventive to make an invention. So if it's like an obvious thing, then it's not something that can be protected. And then the final thing to think about too is ideas can't be patented. And this is where the video game mechanic thing gets complicated, because you want to say, well, aren't video game mechanics just patents for ideas? I low-key kind of agree with you. And it will largely depend upon how their applications are drafted. So Because the logic is, if we could patent ideas, then thinking would be patent infringement. What? How does that work? What if I thought what if someone tried to patent 2 + 2 is 4? And then I wrote down 2 + 2 is 4 because that's the correct way to do that math. They could try to say, Haley, you infringed my patent of the idea of 2 + 2 = 4. Ridiculous. You can't do that. I would say, ew, gross, get away from me. That's the craziest thing I ever heard. So you shouldn't be able to patent ideas because that just is the antithesis of the whole point of the system. You want to protect inventive concepts and processes and methods and improvements, blah, 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 and not just thoughts that happen in people's heads. 2 + 2 = 3. Pretty inventive. Maybe that one could make it through. Let's write a patent claim for that. All right, so the next obvious question now that we know so much about patent eligibility, because it's the 3 elements, what are they? Novelty, utility, and not obviousness. Good job, class. We move on to, well, what's a game mechanic? Because what? That could be a million things, right? And there's actually, when I was drafting my paper, I found this I guess you would just call it a piece. It was from the International Journal of Computer Games Research. Oh, look, it's not showing up properly. Oh, there we go. Okay, cool. So this was Miguel Sicart, PhD in game studies. So, right, that's pretty cool. I didn't even know that was a PhD you could get. That actually sounds kind of dope. But I kind of really like the way that he talked about game mechanics in this, because there's a lot of ways you could talk about game mechanics. I could say a game mechanic is me interacting with something. A game mechanic is the story just doing this, and that. There's a bunch of ways you could define it. So obviously, if we're talking about game mechanic in a court, it's well, we don't have a formal definition of this. So it's kind of how do we go about that? And that's where a lot of issues occur, because either the patent examiner or courts determining patent eligibility are what is a game mechanic? I don't even really know. But so he had a really good quote here that I want to find. A patent that is... Where is it? Well, essentially, I can't find it in the thing, but I wrote down elsewhere. A patent that is provided to enhance computer performance by means of... No, wait, that's not it. Oh, here it is. Rule, algorithm, or method built into the video game that are invoked by agents designed for interaction with the game state. So that was a really engineering-esque way to describe a game mechanic, I thought, and that's what I used in my paper when I talked about this a couple of years ago to consider games. Because we have to first define game mechanic if we're going to do that. So I thought this was a really clever way to describe that. And you might say, Haley, that's still too confusing. I don't like the way this is described. How about this? So you have Rocket League and you have FIFA. So both of these have agents that allow you to play as a soccer game. So there's goalposts, there's the player, there's teammates, there's the ball, there's an arena you're in. So these are all agents, right? But these have vastly different game mechanics, because while in FIFA, I can strategically pass and use a pointer system around my character to determine the arc and direction of where I'll kick the ball. In Rocket League, I can climb up the freaking wall, baby, and I can do a flippy, and I can hit the ball with a speed boost, and I can make it explode, and I can drive over these things on the ground that give me my speed boost back. That's how you kind of have to think about it, is there are similar agents, but it's the mechanics that interact and are invoked by those agents that interact with the game state that make a difference between one or the other game and how they play insanely differently, right? So they're both soccer games. Rocket League and FIFA play totally different because of the mechanics and how those agents interact with each other in the game state. I hope that makes sense, but that's kind of how you have to think about it, and not just the colloquial way in your head. I think a game mechanic is X. Try to think about it that way, in a very engineering-esque way, because that's the way that these patent applications consider game mechanics. And a lot of times the issue comes up in that they're not describing the software implementation of those mechanics. They're describing the gameplay vibes, the ideas behind the gameplay, which shouldn't be patent protected. You can't protect an idea. I can't protect the idea of soccer kicking a ball. That's crazy. But I could potentially patent my software system that solves the problem of the ball always like not going to the right person or something. And back when FIFA was first invented, maybe they could have patented that, but now it's prior art, right? Because that's already in soccer games, so you can't patent that. It's already prior art. So that's kind of the way to think about it. And that sounds insanely complicated, and that's because this is insanely complicated. But let's move on to software patents in general. So I kind of think of it kind of like a rushing nesting doll of ridiculousness that's happening with software patents. So back in the 60s and 70s, software patents like weren't approved at all. And even like, you know, you might say, well, of course, like software was so new. But like software seemed like just ideas that got executed on the computer, which is a super fair way to view that. Like, it's not fair that just because something at the end says and then done on a computer, it means that suddenly it has patent protection. So for a long time, software patents weren't approved. Obviously, generally, the view of software changed over the years, and, you know, patent examiners and patent judges learned more about software and were able to better analyze them. Not so much like games right now. It's almost like we're lagging, right? Like the 60s and 70s of software patents is like the current like couple decades now of game mechanic patents, except unlike in the 70s and 60s, the game mechanic ones are getting approved because they're getting viewed through the lens of software patents. So the judges and the examiners are looking and saying, oh, this is like software. I know software. Approved. What's that, Knuckles? That Knuckles meme I freaking love. Approved. That's literally the patent office. And another thing which sucks is there are certain jurisdictions that are really patentee friendly. The District Court of Texas, looking at you, everyone comes to Texas to litigate their patent infringement stuff because Texas is like, patent holder, you win, you win, you win, you win, you win. So literally we see companies from Japan coming to Texas to litigate because there's a greater chance they're going to win. And I can't remember the percentage. I remember I looked it up, but some insanely high percentage of these cases are decided in Texas, and that tells you something, right? As a resident of Texas, I'm sorry. You're okay, Crowboy. It's just your district court. Let's go over there. Do you think game mechanic patents are having a big effect on the games industry? Maybe that's how I'll conclude with this, because I think ultimately what I want to say is they could. And it's almost like we're like, and we're kind of like hovering, and I don't really know which way it's going to go yet. It's tough. I'll end on that question, Hitmonchan, because that's a really good question. But what was funny with patents is actually copyright used to be the way that all these companies protected their game mechanics first and their game stuff first. But there's this case, Atari and Nintendo. What year was this? 1992, I think. Wow, it's old. Let me see. So in this case, this essentially was a case that caused a lot of game devs, like the bigger corporate ones, to start leaning towards patent protection over copyright protection for their game mechanics. So this one does concern patent infringement and copy infringement. Like, it's not just like copyright infringement. But what's interesting about this one is, so the court essentially decided that, you know, how do I put this? That you can reverse engineer code for video game stuff, and it doesn't constitute copyright infringement so long as you do that in an authorized and above the board way. So what happened here was Atari wanted to get the master chip lock on Nintendo. Had this 10 NES system, and so this was when the NES had come out. So they had a system that made it so like it was hard to essentially pirate games and make them work on the NES because they had this really proprietary secret security system that made it hard for other game companies to make a game that would work in the their NES system. So what Nintendo actually used to do, which is really funny, is if you were in a publishing situation with them with the NES system, you had to send all your games to them. They would implement the 10 NES things to your cartridges, and then they would send it back for you to commercialize. So that's so funny, right? Like, that's such a big open-ended way to do it, but that's the way they did it back then. So what Atari did is it reverse engineered the code, and it literally was like taking layers of the chip off, like figure out how they did this, and it was like layering it down, and they couldn't figure it out. But then they somehow got an unauthorized copy of the source code of the 10 NES system, from the Copyright Office, which is like, I can't remember how exactly that happened. I would love to know. Did they say? Copyright Office. Let's look it up. Atari's attorney applied to the Copyright Office for reproduction of the 10ES program. The application said that Atari was a defendant in an infringement act. Falsely alleged that it was a present defendant in a case in the Northern District of California. In fact, no suit existed between the parties until 1988 in December, when Atari sued Nintendo for antitrust violations and unfair competition. So he lied. That's super illegal. So he went to the Copyright Office and lied, because you get access to certain things in like disclosure. You file subpoenas, and you should be able to have access to information that could help you contest and infringe, like, a litigation. But he went and he lied to the office to get it. That's so bad. That lawyer is very naughty. Naughty lawyer. That sounds illegal. Yeah, it's super illegal. They signed a false affidavit and they were sued by Nintendo. Yeah, amazing. So what they did is then he took that source code, and that allowed Atari to reverse engineer the 10 NES program, and they called it the Rabbit. And that allowed them to circumvent that security program. So what the court said, just specifically about copyright, because they talk about patents too, but I just want to focus on copyright, is that if they had not gotten that source code illegally and they had just reverse engineered the Rabbit based on Nintendo's tech without doing anything like in an authorized illegal manner, it wouldn't have been considered copyright infringement. It was considered copyright infringement here because they lied and got it in a very illegal way. But it wasn't it wouldn't have been if they hadn't done that. So what that kind of resulted in is a lot of companies like Nintendo, who are literally in this lawsuit, saying, oh my God, they can just reverse engineer. We need to patent everything, right? So that just essentially caused them to start leaning towards patents for protecting these kind of things, more so than copyright infringement. Copyright infringement obviously subsists in the work upon creation, so it's going to protect some things anyways, but I always think of this case as kind of like a little flip switch, where those huge corps, the big 1% AAA, Nintendo, Microsoft, Sony, like those big guys, this is when they kind of started thinking, okay, patents are the way to go. So I often think about this case. And then another thing I really want to talk about as well is there is a case that I think should be applied to every single software patent or game mechanic patent analysis, and that's called the Alice Corp case. I actually reread it yesterday, and I hadn't reread it in a couple years, and it is like such a clear and nice case that talks about, it's not video game related, sorry y'all, it's not fun, and talks about the NES and things, so it might be harder to keep your attention with this one. But it essentially talks about whether or not software can fall into a legible subject matter or not. So it's not novelty or utility or non-obviousness, it's whether it's something that could even be protected. So is it an abstract idea, or is it patentable subject matter? So here, there was some, how do I describe this? There was a company that was trying to patent this like way that its computer carried out when two people are coming to a commercial interaction. Sometimes they're worried that the other party might not meet its obligations, and it makes them want to be flighty and leave, or like drop out of the contract or whatever. So what this program did is it was like it allowed people to update things relating to it was essentially an intermediary party that was a computer that allowed two different parties in an contractual obligation with each other to keep track of the obligations to make them feel more secure in their relationship. So I could upload and say, I was supposed to deliver 10 units of X today, update, and it tells them live through this intermediary that I was doing that. And then the other person feels more secure, and then they want to keep doing the contractual relationship, blah, blah, blah. So it takes out the personhood, I guess, of like having to negotiate and check in on each other. It's just automatically done in third-party computer software. So what was held here is that was just an abstract idea. Like, that's just because it happens on a computer doesn't mean that it's now some non-abstract thing. And that's where these software patents really struggle, is like, just because it's housed in computers doesn't mean that it's no longer an abstract idea. And I think that might be the thing that you need to take from this the most, is like, abstract ideas that just get executed on computers shouldn't be patented. Like, that goes against the whole Patent Act and the whole purpose of patents. And you can see I was reading a lot of this. I like this case. to particular. So yeah, here, stating an abstract idea while adding the words apply it to a computer simply combines those two steps with the same result. So it doesn't matter that I did it myself as a human or did it on a computer. What they were seeking to protect was just the idea of doing that, like having an intermediary between two people. And that shouldn't be patent protected because that's just a thing that happens, and that was a common business practice. So yeah, it was determined that it was an abstract idea. It shouldn't be protected. And this resulted with this test that they came up with. And it was actually taken from another case, Mayo, but people always call it the Alice Corp test. So I guess they just like took the Mayo test and improved it. And that's what these law things do, right? Is they like, oh yeah, Mayo Collaborative Services. So they had a framework already in this other case, Mayo. But then it got like improved a bit by them. And what these cases are trying to do is come up with tests that then you apply to the facts of your specific situation to try to understand whether your patent or whatever could be taken down as well, or future litigators. So like 99% of what law school is, obviously it's a lot of reading and stuff, but it's like all my exams were like, I learned all these tests and how to apply them to new fact scenarios. And then my exams were, here's a bunch of new fact scenarios. And I had to go through the test and apply the facts to the test and try to determine whether the fact scenario my professor gave me would pass the Alice Corp test. Like that's kind of how you learn law, is like learning these frameworks and then applying them. And there's so many tests for everything. I've already talked about like 5 other tests. But that's kind of what you can think about with these sort of things. So with this test, first you determine whether the claims at issue are directed to a patent eligible concept. So is it an abstract idea that we're trying to protect? And if so, we go to step 2. What else is there in the claims before us? So does it transform the nature of the claim into something inventive and copyright protected? Or is it just straight up the abstract idea just on a computer now? So that's like kind of how you can conceptualize this test. So I think this Alice Corp test is like awesome, and it's from 2014, so it's, you know, it's getting up there. It's almost 10 years old. I think this should get applied way more in courses. It does in cases. It does get applied, don't get me wrong, but I think this is such a concise, good legal analysis test for determine whether video game mechanic patents should be approved and should be being granted. And then if someone were to contest it, apply this test to figure it out. Creator, you had a long question there. So where does this line get drawn? I've always struggled with that. Like I say, I reverse engineer the code of a game and there are copyright images in the game, but I don't include the images in the software, or rather code of the software to independently draw on those copyright images. Yeah, so the thing with games is, and what's tough with games and copyright especially, is games are an amalgamation of a bunch of different types of copyright things. There's music, there's pictures, there's code, there's video, there's animations, there's motion caption work, there's voice acting work, there's sound effects, there's action effects. Like all these things get shoved into a little ball, and that's the game. And the game itself is copyrightable, but also its elements are copyrightable, depending if they meet the copyright like eligibility criteria. So it's hard to answer your question, because like if I were to reverse engineer source code that contained like Mario in it, and I then used Mario, like you know what I mean? Like I could use the source code for how Mario jumps maybe, and like implement it into my own game and have like a similar style arc of jump or something like that. But I couldn't use Mario. Like Mario's copyrighted to Nintendo. Like, so you'd almost have to kind of like comb through things, and like it's more so a thing with software, the reverse engineering aspect. Like I can't really reverse engineer Mario, like what, overalls, mustache, hat, like no, it's just Mario. So it's more so for like software and that kind of thing. But I understand your question, but it's kind of the same lawyer answer, is it depends on the facts of the circumstance, and that's what I'll end with, because that's what every lawyer says for everything. All right, we really need to actually look at game mechanic patents. So let's do that. Okay, so in a game mechanic patent, we have several elements we look at. Specification, disclosure, claims, and sometimes additional information, depending. We don't have to get into additional information. So let's do it. Let's start with this one. So this one is a Nintendo one, and it just expired, I think, because it was filed in 2003. 2002, so it should be expired by now. So this is a patent for a sanity system for video game. That's what they call it here at the very top. And so this is assigned to Nintendo of America Inc. So what does this protect? This is an interesting one. So it's a game mechanic from Eternal Darkness Sanity's Requiem. And you'll notice that there's pictures and stuff. Patents have pictures in them so that they can illustrate things to the reader and understand it better. Eternal Darkness, yes, everyone knows it. Yippee! So this system incorporates an insanity meter. Look at this. I always love this. These little like things they include. Figure 1. Why isn't this backing up? There we go. These like feature all these little like trees and stuff and tell you how this works. But essentially, like, look, start, set sanity level, process through the game, creature gruesome event, yes, determine a level, blah, blah, blah. So I was trying to describe how the software implements these things. But I know it is Link. Yeah, they put Link here. I don't know why they did that. I thought that was funny, too. Character looks like there, but that's definitely Link, right? Like, that's got to be Link. So what this was trying to protect was an insanity meter that raises and lowers due to certain effects, which ultimately controls element of gameplay. So the more insane you are, the more likely crazy stuff happens, if I had to put that in the most colloquial sense. And look at this. They even included a little figure of an N64. And who's that on the little screen? I like how the patent, like the people writing this patent claim had to draw Mario. Says, when does he have a cape? He doesn't ever have a cape. I don't think I've ever seen Mario with a cape before. I know him. I know that guy. So they just, the reason they included this is just to kind of talk about how the game is implemented on this. This is a very old game mechanic patent. Like this is one of like some of the first ones that are properly entered. And you can kind of tell because they talk about a lot of unnecessary stuff. Here's a bunch more stuff about how the operating system works. But again, this is just like how the game console works. Like, it's not so much how the patent works. So here, I read through this right before this. I wanted to refresh my memory. So my issue with this, and I think this would not be eligible under the Alice Corp framework. I think if someone had questioned this and tried to get it revoked during its 20-year existence, it could have got revoked because this does not describe software that implements an idea and actualizes it and solves a problem. This just straight up talks about a game mechanic as an abstract idea and is like protected. And I was like, reading through this again, I couldn't believe how like there's barely that any discussion on the software that implements it. It's just like look at this background of the invention. Video games, such as RPGs and the like, typically include a game character that proceeds through the game with one or more physical conditions of the character, such as an injury, strength, or stamina monitored by the game. Like, they're just talking about games in the most generic way. And then they say, a setting unit communicates with the controller processor. So this is kind of software, software-y, and sets a sanity level on the game character. The sanity level of the game character is modified during gameplay according to occurrences in the game, wherein a modifying amount is determined based on character reaction and an amount of character preparation. The control processor controls game according to the sanity level of the game character. Like, that just to me describes like the idea of having a sanity meter that goes up and down and things change. That really, to me, isn't describing, oh my god, we've tried so hard to have a sanity system in the past and it just doesn't work because it's too hard on our game consoles and whatever. Oh, thank you for the sub, MCAS. Aw, thanks for the new Game Plus content, Halo Engineer. I love patent law. Love it. I wish I had your knowledge of engineering because, honestly, this is the hardest part, is reading these applications. And this is like a chill one that doesn't even have that much software stuff. When we get to the Nemesis one, you'll see it's like word barfy like crazy. But okay, so essentially, I'm running out of time. I need to be faster. I don't think this would pass that Alice framework because it's an abstract idea that's getting approved. Preferably, levels of insanity will be a sliding scale. The more severe the insanity, the lower their level, the more players' control, animation, and targeting system will be affected. In addition, the more extreme the insanity, the more hallucinations the character will experience. There may be a certain number, such as 3, distinct levels of sanity loss. That's not software. That's a cool idea for sanity levels. Like, that's just... How is that? I still honestly like, and maybe this is just, I'm not a patent agent and I don't know, but I've read a lot of these. I don't understand how that's just not an abstract idea being implemented by software. Again, the Alice Corp thing. Is this just that on a computer? I think so, because they don't really detail too much about how this works. And here they detail all the different hallucinations that could happen, which I don't even know why that would be applicable here. Creature sounds, footsteps, earth rumbles, loud noises coming from beyond a doorway, bleeding walls, enormous roar that emits from a tiny rodent, mouse or rat, dripping water. Like, why is this mentioned? This isn't, you're not solving a problem. You're listing cool stuff that happens in your game. Like, that's super cool that a statue could track the character with his head moving, or a suit of armor moves. How is this in a patent application? Like, I'm truly bewildered by this. And then at the end of the patent application, you can see all the claims that they make. So this is like the language here is like what's getting protected. Who actually writes these? I thought it'd be a lawyer type person, but it seems like you need to really understand the technical details. Patent agents write these. Most of the time, patent agents have like a degree, some kind of degree that helps them, and they'll like only write, or they'll, I don't know if they only write, but they'll focus on patent claims in their relative field. So if I wanted a patent filed in the pharmaceutical business, I would find a patent agent, so someone who has a degree in like a medical degree and a law degree, possibly also an engineering degree. So you can see why these things get really expensive, because you need to find somebody who knows your market and has a law degree to write these. I mean, someone could write these without a law degree. I would highly not recommend that occur. But yeah, so if I had like a super specific industry that I wanted to patent in, I'm looking at lots of money I have to spend to get my patent claim right. Hence why disclosure is so important. You don't want to get rushed into disclosing, because all of a sudden now you have to put together tens of thousands of dollars to get this approved. But yeah, anyways, I could go into all the things they claim, but it's really just, isn't it cool how this happens when this happens? It's an idea, right? Like, that's what I think. It's expired now, so I guess whatever. But again, it just kind of shows that the people that are approving these, the engineers, don't really have the knowledge of games, I don't think, or some of them don't, to be like deciding whether these types of things pass or not, because they hear like a little bit of software language, and then the software language they're like familiar with, like that kind of seems software-y, and they approve it. But it's like, again, the Russian nesting doll. It's like, I don't think game mechanics should be completely harbored inside software patents, because there's ultimately a lot of other tech that goes on here, and is a patent examiner gonna know every single video game that's ever come out to know whether it violates prior art or not. And that's something that comes up with the next one that I really like talking about, which is this Bloober one. So remember the game The Medium? The Medium was that game. It came out in 2021. It was kind of like psychedelic, like, not psychedelic, but it was like the thing that they're patenting here. And with this one, I think it has some utility problems and some prior art. Not to come after whoever drafted this, because honestly, like, it's, again, I'm not a patent agent, and there's some good language in here, but ultimately, I'm just like, kind of like, is this not just already existing in previous games? How did it get patent protected? You can see lots of images here. So essentially what they were trying to protect was, it allows for a dual gameplay effect, wherein one person, the player, can control a character who moves in two different environments rendered at the exact same time. That was a game for sure, says Rich, yes. So one of the locations is normal looking, and one of the locations is like a psychological horror environment. So I want to talk about this really quickly because we're running out of time. Just in terms of how about novelty, we'll skip out on the utility, but a lot of what's described here is kind of like, I've seen this before in other games in parts. There's no one game that does all these things necessarily, or maybe there is, I'm not sure, but there's quite a few other games that like take the things that they talk about in this patent application and essentially already do it. So like, let's look here. In prior art, there are video games focused mainly on interesting capturing stories, so-called storytelling games. So far, the storytelling games and their associated types, such as adventure and narrative games, have been played on a single display, and the plot has been developed usually in a single story universe. And then they kind of talk about a few different games that kind of play on this. So there's obviously split screen games, like we've all been playing split screen games for forever. They talk about Lego Marvel Superheroes, where you can switch between a bunch of different characters playing at once, and then the computer will control the other characters while you're the main playable character. And then they also talk about Brothers, A Tale of Two Sons, and talk about how one controller can be used to control two characters at once, and they exist in the same universe. But then they go on to say, the problem solved by this invention, so this is utility, right? They're claiming utility here, is increasing the amount of information transmitted to the player by the game time per unit. So that seems like a problem that actually needs fixing. And I kind of was like, okay. So there's a problem where maybe the software, the hardware isn't able to transmit that much information in order to house two different playable systems at two like playable environments at once, where you're controlling one character within both at the same time. That seems like a legitimate problem. Like, is it because the software or hardware isn't sophisticated enough? Is there too many polygons on screen at once and it just goes crazy? Is it like, I don't really know. That's my engineering. I don't have an engineering background, so I don't know. But that's an interesting utility problem solved. But ultimately, I think what's described here is the key feature of this invention is the way of playing in a video game for a single player involving simultaneous controlling of several character avatars placed in several virtual realities that constitute separately present story universes. One player using one controller to control simultaneously one character with several avatars placed in two or more virtual worlds at the same time. I'm confused on how that's not something that I could argue exists in prior art already. I actually did a presentation on this. I had to do a presentation for. Here, let me flip it. Make that small. I don't need that huge. Hopefully this kind of looks shiny. My bad, y'all. But it's essentially, this was like a video that I made that kind of took that gameplay. You can kind of see it. Oh, it's kind of like frame ratey and stuff. But it shows the gameplay happening in dual screen. And like, this is the normal where the character plays like in the real world. And then this is like the psychological horror other world that they're existing in. But then like kind of what my point I was trying to articulate to my professor was like, this kind of already exists in other games, just with slightly different variants. So like, could this not be something that's obvious because of what's already out there in the game space already? So with Tales of Two Brothers, we see like two different people controlling two characters in one environment. So it's not one player controlling one. But then I was kind of thinking like a Tale of Two Sons is similar, like, or Tale of Two Sons. What's this game called? Wow, I can't remember. The prison one where they're trying to escape from, it's by the same developer. No, it's not by the same developer. It's by the same developer of It Takes Two. What is this? A Way Out. Thank you. Thank you, MinnMax Show. Way Out. My brain died there. But then the one I was thinking about the most, and this doesn't look good, does it? It's like so frame rated. It's because this is a PowerPoint. But I was showing some footage there of Titanfall 2. So you know that one level in Titanfall 2 where you can jump between the two realities, like quickly? So I can like, there's one in the past where everything's on fire, and then there's one in the present where like there's enemies. It's like the best level. Yeah, I totally agree, Redo. It's like such a good level, and I started thinking about that level, and I'm like, could I argue that that level is doing what this does, like to the point that it might be like make this patent not novel? So like, there's two different game states happening. The only difference is we're not seeing them active on screen at the same time. So yeah, I press a button on the Titanfall 2 armor or whatever I did. I can't remember. I played that level so long ago, and it flips me between the two game states. But I'm actively in those two game states, and it's up to me to flip between the two of them. So could I potentially argue that their problem, increasing the amount of information transmitted to the player by game per unit, was that not already solved in Titanfall 2? When they were able to have those two levels exist simultaneously, and the player can swap between them with a moment's notice, and they're ready to go, and those two game states are exactly there. But the one thing that's missing is the player never sees those two levels at the same time and acts in them at the same time, like in the medium. So what I want to know is, the developers of Titanfall 2, tell me please, is the back end working so that that information is being transmitted at the same time? Like, are they actively having the playable character running through both of the locations at the same time, and my switching between them just like switches the screen so that I can see the right one that I'm under? Or alternatively, is it just like, you know, they're only running one at a time and they have very good back-end system to allow the new area to be rendered at the exact same time? So that probably was a very confusing way to phrase that, but this points out the problem with the prior art thing. Like, I don't think a patent examiner would think about not only Titanfall, but that one level from Titanfall, right? Like, not only did they have to know about the game mechanics in games everywhere, you have to know about every level because that's not used elsewhere in Titanfall. It's only in that one level. So not only would the patent examiner have to have played Titanfall and know about it, it had to have played every level to think about that and consider whether that was prior art or not. Now, I could never contest that unless I wanted to go to court and try to get this revoked, but like, why would I do that? And it's like, that's what's really frustrating about this, right? Is could these things get revoked? Like, are they meeting the criteria? Here's the claims underneath. The invention is claimed as a method of simultaneous playing in single-player games with the storyline and narrative realized with the use of a computer device, using at least one device for image display and at least one computer device to generate game images, and at least one game controller controlled by a playable character, and the playable using one controller controls simultaneously at least two characters. Protecting, like, it's convoluted and it's hard because indie game devs have to come and read these, and essentially the onus is on them to understand what this means and then make sure they're not infringing on this. But at the same time, if Bloober, like the medium, invented a really unique way to like save on software processing and have these two things happen simultaneously, shouldn't they be rewarded for all the effort that went into creating that system? But it's like, you can see how it's hard. We're thinking back to like the reason that we grant IP rights in the first place. Should they get rewarded for the effort into making this system? Or is this hindering the video game industry as a whole because it's stifling creativity and now other people can't use this system? Plus, it's just hard for them to understand what this patent is protecting. And like, unless you have a lot of money, like, indie devs can't really contest these kind of things. So if they were to get sued, not to say that they would ever sue anyone, maybe they just have this to increase their patent library and like have more value in their company as a whole. And they don't actually intend to litigate or go after anyone with this. But we don't know that until they do. So that's kind of the tough place we're at. But let's get to the Nemesis system, because we all got to talk about the Nemesis system, and then we'll be done. So the Nemesis system, I guess all I'll use this one for is to hammer home that this is extremely convoluted, and it's like, it's going to be hard for other game devs to read through these and know whether they're infringing this patent or not. Look how many pictures there are. So I'll give it to this one. It's very, like, it sounds really technical. Like, there's a lot of technical software language in this one, and I don't, so let's talk about the context of this one, because this patent got approved in 2021, but Warner Brothers was trying to get this patent since 2016. So this is for Lord of the Rings Middle-earth, Shadow of Mordor. Yes, the 2017 game. And what they were trying to protect was their Nemesis system, which essentially is kind of like, if you interact with an NPC, a secondary NPC also has effects put onto it. So like, if I were to hit an orc, that orc's leader would be like, oh, I don't like her. Like that, like, I guess is like the most basic way I could possibly describe this system. And this is a really long one too. Like, you can see how detailed it gets. Look how little that it doesn't even show up on the screen. It's just like little bits and pieces. But essentially, so they were trying since 2016 to get this approved. And this one's interesting because they 100% thought about the Alice Corp analysis. Like, you can tell by the way this is written, Alice Corp was like what they were thinking about, because it got rejected in 2016, and then I think it got rejected again in 2019. Like, they were trying to get this approved, and only after they probably had so many lawyers in on this, drafting this in the perfect way that essentially made it sound more like software executed something that has an incentive element that helps solve a problem, not the abstract idea of, isn't it cool that I have a nemesis implemented into a game? Like, other NPC characters become my nemesis in a game. Like, that can't get protected because that's just an abstract idea, but the way they execute it via their software could potentially be protected, so long as it's drafted like in a very specific way, I suppose, is the way to think about it. Is there a wait period before you can file after being rejected? That I don't know off the top of my head, Crowboy. I believe there is. But you also have to think about, too, is like, if they filed in 2016, like, and then the game came out in 2017, and they filed again in 2019, isn't there novelty issues here? Like, is this considered new? They must have been updating the patent every time because, again, you can file for an improvements on technology. So even though they may have disclosed their very first application they sent in, if they improve it every time, they could argue it's like a whole new application because it's an improvement on the previous technology. Again, it was probably took a bunch of lawyers to figure this thing out. It takes a lot more to read it. But what I find frustrating with this one is what it tries to protect. Where's that claim I highlighted? Let me find it here, and then we'll be done because we are over time, I think. Yikes! Time flies. Claim. It's like the list of claims. It's so complicated. Oh my god, they have so much detail. It's just word barf to me, honestly. But I've read through it and it's fairly hard. And again, how is they talk about all the different things a non-player character can do when they attack. How is is it getting to a point where devs have to get a patent search before they make their games? Like, are we getting close to that? I don't know. Like, part of me thinks that maybe not, and part of me thinks maybe that is required. Oh, apologies, I can't find the claim section. Oh my god. All right, well, essentially what I found was interesting was the way that they described the claims was extremely convoluted. And under claim... Oh, here it is! So the invention claimed is a method comprising... Are you ready for how they describe this? It's ridiculous. Controlling by a processor game events in a computer-implemented game, the game events involving an avatar that is operated in response to input from a player and a first non-player character that is controlled by the processor to respond to and automatically oppose avatars based on first character primary parameters defined in a computer memory, detecting by the processor occurrence of a predefined one of the game events involving an interaction between the avatar and the first non-player character. Like, what does that mean? So essentially I sat down, and this essentially just says, if you interact with a non-player character, something happens. That's not protectable. That's literally every video game thing that ever happened. That's literally like me being Kirby and jumping once. Like, that's, or jumping on something, or Mario jumping on a Goomba. That's that. But here, what they add here, and this is the thing they're trying to protect, is changing by the processor second character parameters. So I interact with, no more NPCs, everyone. Yeah, that's what it feels like. I interact with the first non-playable character, and what they're protecting is, and then that has an effect on the secondary non-playable character. And of course, there's all these more claims that get into more detail. But then under claim 14, it kind of goes back and still tries to protect the first thing. It says the method of claim 1, further compromising changing by the processor. So that's the first thing I just talked about, interacting with outputting to at least one second output device, an indication of the first character's parameters that are changed by changing the first character. There's literally spelling mistakes in here. By the changing the first character parameters. So this is trying to protect that first part, I believe, and say that, like, just interacting with the first playable character is patent protected. And this is where I think just like word barf, like software word barf, and putting a lot of pictures and putting a lot of like software language in here. But if we were to dig into this and really try to get into the nitty-gritty, is this not just an idea? Is this not an abstract idea that's getting executed via software? And if we applied the Alice Corp analysis to it, could we come to that decision? And that's the thing that I don't know, and that would require tens of thousands of dollars in litigation fees to determine. But I think you could, and I think this is just, it's just, and to answer your question asked at the top of the show, do I think this is like hurting the game industry? Do I think this is, shouldn't be happening? I think that patents are supposed to do something positive, and that's kind of the intent of the whole patent system. They're supposed to grant you a monopoly so that you can recoup the cost it took to invent your invention or your improvement, what have you. And if what we're doing is just flooding the system with potentially and arguably abstract ideas which shouldn't be patented in the first place, that's going to hurt any industry, no matter how creative and like free-forming it is. Like, it doesn't matter if I'm talking about video games or pharmaceuticals or mathematical devices or what have you. If we're just flooding the market because the market hasn't quite, or like, you know, the patent office or patent judges or whoever hasn't quite figured out how to assess these things and to really root through the software language and say, is this an abstract idea or not? Or does this, or have other games come out that do this already? Or is this useful? Or is this non-obvious to a posita? Then it brings up the question, who's a posita here? A game developer? Someone who's played every single video game ever made? Is that the posita, but also has development knowledge and understands how to make video games? That posita is so specific and has to have such a crazy huge knowledge, because what's ultimately tries to get protected are the gameplay mechanics, not the software that implements them. So someone would have to, if we're going to say that it gets protected, know every single game mechanic ever made in the history of ever to know if the novelty requirement is passed or not. And how are we going to do that? How are we going to, quite literally, it's so complicated. But how about we end on that confusing and upsetting note? Because then I'll sip my claw again. And yeah. So I understand that patents are very confusing. I hope this was somewhat enlightening and you learned a little bit more about patents. Because this is a really complicated thing. Is this the dark middle chapter of this series? This is the Shadow of Mordor. Yeah, this is the Shadow of Mordor game in this series, for sure. But thank you so much for hanging out. I really appreciate it, and I really appreciate you voting for the show again. I don't know, round 3 could be looking at publishing agreements. I think someone in our channel, I think your name, sorry, Jacob, I can't remember your last name right now, in our suggestions channel, said looking at publicly available publishing agreements could be a fun third thing. Because I deal with those all the time, and I think publishing agreements are super interesting. And I learned everything about publishing agreements from the director of my firm, Kellen Voyer, who's been looking at publishing agreements for like 10 years. So him and I get to work a lot together on those. He did a talk at GDC just this last year, which like the whole room got filled for it, which was super fun. But I've learned a ton from him on what we look for in those agreements, what is often missing, what's often drafted incorrectly. Obviously, one of the most important things is licensing. Like, is the licensing drafted correctly? And then other things like what's a fair percentage cut? That's largely gonna depend on the situation. But our firm actually took a bunch of publishing agreements we saw and did a bunch of like data and like said what's the average royalty cut, which whatever. So I could like talk about that, what we found, and then just talk about publishing agreements in general. That could be a third thing if you're all feeling like nerds. But again, yeah, this was News Show Plus. Haley's Laws, Claws and Claws. I didn't drink a lot of my White Claw. Apologies again. But thank you so much for joining, and thank you again to the lovely supporters at patreon.com/MinnMax with 2 N's for voting for my show. And I had a lot of fun, and I sorry I word barfed at you about patents for over an hour. Oh, I'm way over. Apologies. But thank you so much for joining. Bye, everybody.
Every week, we let Patreon supporters choose which new show we create with New Show Plus. Should we create another episode of the show you just watched? Check out the biggest new game release? Get into Sea of Thieves? Create an exercise show? It is your call. So thanks to everybody who subscribes on YouTube or supports us over on Patreon. MinnMax exists because of you. As always, if you enjoy MinnMax content, any help telling a friend is appreciated.